Hello everyone, welcome to Company 360. This is Anirudh and today we will discuss what is trademark amendment, rectification and cancellation. The Trademarks Act 1999 and the Trademark Rules 2017 give rights to the trademark owner as well as third parties opportunities to file amendments, rectifications and cancellations in respect of the trademarks at both pre and post registration stages. First, let's look at amendment and correction. An amendment of particulars or correction of an error in the register may be mere clerical change to the extent that such trademark is not changed substantially. As application for making a substantial amendment, such as for substantial amendment in the trademark as applied for specification of the class of goods or services, accepting reclassification or any substantial amendments or changes to the nature of the trademark application is not eligible. Let's look at pre-registration amendment. Amending trademark applications is governed by Section 22 of the Trademark Act, read with Rule 37, under which the registrar may, on such terms as he thinks just, at any time, whether before or after acceptance of an application for registration, permit the correction of any error in or in connection with the application or permit an amendment of the application. Next is the post-registration amendment. Further, under Section 58, read with Rules 40 and 101, the registrar may, on an application made in the prescribed manner by the registered proprietor of a trademark, correct or change any error in the particulars or entry of the registered proprietor of a trademark, cancel the entry of a trademark on the register, or strike out any goods or classes of the goods or services from those in respect of which trademark has been registered. Thus, there is a provision for consequential amendments or alterations to be made in the certificate of registration. Next part is rectification and cancellation. Rectification refers to the correction of an error or omission made in the trademark application as recorded in the trademarks register. On the other hand, cancellation refers to the process wherein a party seeks the removal of a trademark from the register. Rectification of a trademark. Section 57, read with Rule 97, gives power to the registrar to cancel or vary registrations and to rectify the register. On application made in the prescribed manner to the High Court, earlier it was Appellate Board, or the registrar, by any person aggrieved, the tribunal may make such order as it may think fit for cancelling or varying the registration of a trademark on the ground of any contravention or failure to observe a stipulated condition. Further, any person aggrieved by the absence, omission or error, defect in the register without sufficient cause or wrongly remaining on the register may apply in the prescribed manner to the High Court, who may then pass such order for making, expunging or varying the entry as it may think fit. The authority, that is the High Court, may, on its own motion or having after given notice in the prescribed manner to the parties concerned and after having given them an opportunity of being heard, pass any order for rectification of the entry. The landmark case of Mr. B.V. Ilango Himachalpati versus Rank Xerox Limited and others, wherein 7 rectifications were filed against the subject mark Xerox on the grounds that it had become a common and generic word. However, the IPAB rejected 4 out of the 7 rectifications. It further held that long, continuous and extensive use and acceptance by the public of the trademark are factors that ought to be considered in the IPAB's discretion, and the present case was an apt example of the same. In another landmark case, Vishnu Das Trading as Vishnu Das versus the Wazir Sultan Tobacco Limited, wherein the subject mark was Charminar, Vishnu Das Trading had filed a rectification application on the grounds of non-use with respect to chewing tobacco that had been permitted by the registrar. The matter was heard in appeal before the Supreme Court, where it held that the rectification of the registration for limiting or confining the registration of the trademark by the party to particular goods cannot be held as illegal or unjustified. Finally, let's look at cancellation of a trademark. Section 47 of the Trademarks Act 1999 provides for the removal of a registered trademark from the register and imposition of limitations on grounds of non-use. A registered trademark may be taken off the register in respect of the goods or services in respect of which it has been registered upon. application made in the prescribed manner to the registrar or the High Court by any person aggrieved on the ground either that the trademark was registered without any bona fide intention on the part of the owner to use the same in relation to the goods or services covered by it, or that up to a date 3 months before the date of the application, a continuous period of 5 years from the date on which the trademark had actually been entered in the register or longer had elapsed, during which there had been no bona fide use of the trademark in relation to those goods or services in respect of which it had been registered. A cancellation may also be filed on the grounds of malafide registration or wrongly remaining on the register, which grounds need to be established conclusively before the adjudicating authority by the party making the claim. The terms rectification and cancellation and revocation or invalidation may be used interchangeably. With this video comes to an end. For more knowledge or any assistance required in this field, you may connect to Company 360. Visit the Company 360 website now or get in touch with us with these contact details. Thank you for watching this video and have a nice day ahead.